Good evening. On behalf of the American Constitution Society and its Washington, D.C. lawyer chapter, I'd like to welcome you to a progressive view of antitrust. I'm Deborah Perlin. I'm the Director of Policy and Programs at the American Constitution Society. Founded in 2001, ACS is a national network of lawyers, law students, judges, and policymakers who believe that the law should be a force to improve the lives of people. ACS works for positive change by shaping debate on vitally important legal and constitutional issues, such as the one we'll be discussing today. We invite you to follow ACS at ACS Law and the Washington, D.C. lawyer chapter at ACS_DC chapter. Despite a general consensus among progressives that our antitrust laws need to contend better with rapid industry consolidation, there is disagreement about whether what is needed is a complete overhaul of the system or a tinkering around the margins and better enforcement. Today, critics question whether the existing antitrust regime, designed in the 19th century to address the consolidation of oil and steel companies, railroads, and financial institutions, is able to effectively address contemporary concerns about persistent economic inequality and industry consolidation in retail, technology, hospitals, and airlines. Just last week, these concerns took center stage at the U.S. District Court for the District of Columbia, with AT&T squaring off with the U.S. Department of Justice in a long-anticipated antitrust trial, as the two sides dispute whether the company's planned purchase of Time Warner would be good for consumers or an expensive drag on innovation. With these concerns in mind, in 2017, the Democratic Party released a new platform, A Better Deal, which includes a proposal to crack down on corporate monopolies and the abuse of economic and political power. The proposal would rewrite U.S. antitrust law by expanding the criteria that antitrust agencies use to evaluate proposed mergers and would institute tough post-merger review. We are fortunate to have a panel of experts here with us tonight to discuss the current state of antitrust law and where, as progressives, we want to see it going. To moderate this discussion, we have a good friend and DC Lawyer Chapter Board of Directors member, Sean Flame. Sean is an attorney in the Office of the Secretary, Office of General Counsel at the U.S. Department of Health and Human Services. He also previously worked for Commissioner Julie Brill at the Federal Trade Commission and published an article on antitrust and copyright law in the New York University Journal of Intellectual Property and Entertainment Law. Please join me in welcoming Sean.
Thank you, everybody. To start at the panel, I wanted to actually ask the audience a question. How many people in the audience are familiar with antitrust law or have read a lot about it recently? Anybody? So we have about half the audience. What I'd like to do to kind of start off the panel is to talk about basically what antitrust law is, what it's and kind of the current happenings in there, and then kind of delve into its past to see how it ended up the way that it is now. To begin that, I'm actually going to start with Mr. George Cary, who's a partner at Cleary, Gottlieb. He has a history of working for in antitrust law for many decades. He used to be at the Federal Trade Commission in 2008, and when he was there, he participated in what historically was a record number of merger transactions that was happening during the Clinton administration. I think that record might have been shattered last year in 2017, but can you bring us up to date on that and everything else? Thank you.
I'll try.
Yeah.
I think this is on, is it?
One more. That's it.
All right. So I was asked to talk a little bit, just for the benefit of those who are less expert on antitrust law, about what antitrust law is, and then bring us up to date in terms of current enforcement. I'm going to reveal in my comments that perhaps some of the suggestions about expanding the scope of antitrust to cover other topics are not necessarily positions that I agree with, but at least that'll set up a lively discussion. I'm going to start from the current and then go back and then come back to the current. So my own view of what antitrust law is about, it's about economics. It's about the notion that when people or companies get together and try to corner a market, that is to control so much of the output in a market that they have the discretion to withhold that product until people are willing to pay them higher prices because of the false scarcities that's created. That's what antitrust is all about. And that concept carries through in all of the antitrust statutes, really. So you start with the Sherman Act, price fixing. You've got 5 manufacturers of a product. Those are the only manufacturers of a product. They're competing vigorously. They compete vigorously by expanding their output to the point where the last sale they make is just barely break even, because if you don't make that sale, your competitor will make that sale, and if he doesn't make that sale, the next competitor will make that sale. That's what competition is about. Driving output to the point where marginal revenues equal marginal costs, benefiting consumers and benefiting society, because scarce resources are allocated in the best possible way. Now, when you get together and fix prices, what you're doing is saying, I'll agree not to sell at a low price, close to the cost, if you agree not to do that. And in effect, we're agreeing to withhold product from the market. As a result, we're forcing consumers to take it or leave it at a higher price. That hurts consumers. It also reduces output. Consumers are hurt because they pay more. Output is reduced because we're creating a false scarcity, and prices go up and our profits go up. And it's bad for society because units that society values more than the cost of producing them are not produced in this scenario. Price fixing is therefore illegal under the antitrust laws, number one. Number two, you can go to jail for it. So what are the rest of the antitrust laws? Well, mergers are just like price fixing in a sense. The issue there is if companies combine, they control output, they can reduce the output they make available and force up prices. Pretty much the same mechanism, except instead of agreements across firms, you have a single firm that has the ability to do that. Vertical restraint, same thing. You tie up a distribution channel. You can restrict output, escalate prices. Finally, monopolization, Section 2 of the Sherman Act. Again, it's the same concept. A single firm uses exclusionary tactics to corner a market, create artificial scarcity, raise prices well above cost, make a lot of money, hurt consumers, hurt society. That is, I think, if you want to call it mainstream or generally accepted Republican and Democratic notion of what the antitrust laws are about. Now, it wasn't always so. Back in the 60s and the 50s, that concreteness of concept was not there. The courts were kind of stumbling around, applying different standards, different rules at different times in an inconsistent and, some would say, an unprincipled way. Enforcement was up. The courts were friendly to enforcement, but there was no coherent, comprehensive system that could tell businesses, could tell consumers when they were in trouble, when they were not in trouble, what the antitrust laws were all about. That started to change in the 70s. I hate to admit it, but I was a young staff lawyer at the FTC in those days and witnessed a lot of that change. It continued that evolution through the 80s, maybe a little bit more extremely than many of us would have liked. Came back in the Clinton administration, but in the Clinton administration there was a general acknowledgement that what I said is what antitrust is about. Our resources used efficiently, our consumers being hurt. And that trend has continued to the present time through the Obama administration and even today. The debate has been around burdens of proof. The debate has been around when you're uncertain, how do you make the call and what is the quantum of evidence? And there's shifting back and forth with different administrations, but the underlying concepts and principles have been the same. Today, they remain the same. I think a lot of people were surprised that the Trump administration challenged AT&T Time Warner. The principles they applied in doing that are the same principles that I've described. Can a firm with market power in the distribution of television content restrict output, raise costs to their competitors, and earn monopoly rents? That's the question in that case. It's the same question that we've been asking for 30 or 40 years in antitrust.
Okay.
Thank you, George. I suspect that our next speaker is probably going to have a little bit of an issue with some of those assertions. Michael Cadis is Director for Markets and Competition Policy at the Washington Center for Equitable Growth, and who works on competition and antitrust policy. Before that, he was with Senator Amy Klobuchar's office, where he worked on the Senate Judiciary Committee for Antitrust. And before that, he was at the FTC. We were actually there at the same time. He was the attorney advisor to Chairman John Leibowitz. So, Michael, thinking about what George said, is antitrust all about economics? He said in the 70s something changed. What changed, and how did we get to where we are now?
Okay, so is it on? Great. So, for me, it's a little funny to be here in front of sort of anyone besides the antitrust bar thinking about antitrust law. I actually wanted to be an antitrust lawyer from like the 8th grade when I realized I was neither going to be tall enough to play in the NBA or had the athleticism to be a baseball player. And when I went to law school, everybody looked at me like I was crazy for wanting to be an antitrust lawyer. So what I really wanted, to circle in on this question is, what has happened in the last 2 years to make antitrust something of public policy, of public policy issue rather than just a technical internal legal discussion. And I think it ties into very broad political trends. At an anecdotal level, I think a lot of you can look at the election of 2016 as there were a lot of people out in the country who feel sort of alienated from, they feel like they have losing control of all parts of their life. They feel like the corporate headquarters are no longer local. The internet is, provides great benefits. On the other hand, I think all of us have sort of experienced the notion that having interaction with a company over the internet and the customer service often is a disaster. Not that is necessarily directly related to antitrust, but I think following on that, there's been a series of empirical work, not done by antitrust lawyers or by necessarily antitrust economists, raising some really disturbing findings, right? So we've known for a long time that the share of national income going to labor is decreasing. What now they're finding is that is not going to capital, it's going to corporate profits. We also know that high corporate profits have become persistent, right? Now, if you sort of believe in competition and free markets, you expect that over time, some companies will earn a lot of money and some companies won't, but it should change. Now, in 1993, a company that earned substantial profits had about a 50% chance 10 years later that they would continue to. Now, in 2003, it was about an 85% chance. Right, so that's not the sign of sort of the dynamic market and the churn in competition that creates opportunity. Just in the last month, there have been studies coming out where macroeconomists are looking at these puzzles, right? So they're trying to figure out how to model the economy, and all the rules their traditional models can't explain why certain macroeconomic effects are there, and then they plug in a measure for monopoly power, and all of a sudden the models make sense. So are any of these proof positive that we have a monopoly problem? Probably not, but they are all disturbing. So it is important, I think, at this point to step back and say, one of the tools we use to protect us from monopoly power, in fact, the most direct tool is antitrust enforcement. And we need to think about, is antitrust enforcement really protecting competition, making sure consumers have that benefit, making sure that dominant firms aren't preventing new businesses entering the market, making sure that we're getting the full benefit of innovation. And what I would say is, if I think that the honest sense where we are is, even before you sort of get to sort of the question you asked, is even if we take sort of a narrow view of what antitrust is supposed to do, it hasn't done a very good job in the last 10 to 20 years. And one way to think about it, at least for the non-antitrust lawyers, maybe we're more sort of familiar with civil rights law, right? So there's two types of discrimination cases. You can bring disparate impact and disparate intent, okay? right? Disparate intent, you have to prove directly. And there's always a fight about what disparate impact is you don't have to prove intent. And what sort of happened in antitrust law would be like if we just got rid of disparate impact at all, entirely. That the only way you could bring a civil rights case is if you could prove intent directly. And I think where the courts have developed the doctrines that control antitrust law is they've made it so hard to prove antitrust violations that the government is left forcing to contest the most obvious cases, which means you're missing the next order cases. And as a result, antitrust as an enforcement tool is not capable of dealing with the challenges in front of it. And so regardless of, so I think my view is a critical first issue we have is that we need an antitrust law that is more aggressive, that understands that needs to be put the lever and the balance, put the thumb on the side of competition, and understand that under enforcing the antitrust laws certainly means consumers are worse off. They pay less they pay more money for worse products. They are poorer off. But it probably also means we get less innovation. It also means that it's harder to start new businesses. So when we're trying to figure out how we want our antitrust laws to work, we need to realize that under-enforcing has a huge impact that goes beyond even the scope of its own case.
Great. So the next speaker here is Lena Kahn, who's the Director of Legal Policy at the Open Markets Institute. I believe you started out your career as a journalist and then decided to go to law school, which is probably the opposite of what I would have done myself. But fortunately, you are here with us and you can share kind of your work. Now, Michael talked a lot about the problems of where we were now. What are some solutions to that problem? What are the things that we can do to revitalize antitrust enforcement for the 21st century?
Let's go over here.
There. Push it one more. There you go.
Some of us don't get likes.
Yeah, there's.
Oh, I see. Great. Well, thanks to ACS for hosting this discussion. I think we're at a really interesting moment in kind of the antitrust debate, and I guess I want to answer your question by looking a bit more broadly at the kind of anti-monopoly debate happening. So antitrust is one tool that we have, but I think anti-monopoly is about how we view the political economy. And I think one of the biggest differences over the last few decades has been how technocratic antitrust has become. So I want to kind of zoom back and look at the broader vision of anti-monopoly that is now being recovered, and kind of talk about what are some of the key principles and tenets of this rising anti-monopoly movement and interest. So one is that anti-monopoly really used to be seen as a key tool and philosophical underpinning for structuring society on a democratic foundation. Anti-monopoly was about creating a system of checks and balances in our economic and commercial spheres, in the same way that in our constitutional system we create a system of checks and balances and disperse power. And the reason for this is that we recognize that concentration of economic power aided the concentration of political power in ways that could overwhelm public government. And so anti-monopoly was really seen as a key democratic tool. There's this great quote from Justice Brandeis, where he said, "What does democracy involve? Not merely political and religious liberty, but industrial liberty also." And this term industrial liberty was really used to capture the idea that the structure of our markets and our economy really determine how much real freedom people experience in their day-to-day lives. So for most people, their day-to-day experience of power is not with their member of Congress, but is with their boss, is with kind of in the process of negotiating their wages, their income. And I think this gets to kind of some of the concerns that Michael was referencing around, how people are now experiencing power in a sense of real powerlessness. I think the second recognition that there used to be around anti-monopoly was that it was really more than just antitrust. So antitrust is really one lever in this broader competition policy toolbox, but there are all sorts of levers across the federal government. So the USDA, the Federal Reserve, the FCC, the Department of Transportation, all of these agencies have anti-monopoly tools and levers to ensure that the markets they're overseeing are competitive, or if these markets necessitate some level of consolidation or monopolization, that those forms of power are kind of accompanied by some level of public oversight. I think another recognition that we used to have was that anti-monopoly does not necessarily mean that big is bad. So I think some of the discussion that we see in the media kind of assumes that there are kind of two ends of the spectrum. You either are promoting a system of like total fragmentation and total decentralization, if you're kind of pushing back against some of the monopolization that we're seeing. But the kind of original approach to anti-monopoly recognized that some sectors tend naturally towards monopoly. This was especially true in network sectors. And in these instances, the answer was not necessarily to break the firms up, but was instead to design a system of public regulation that ensured that these networks promoted the public interest, and it kind of prevented gatekeeper firms from exploiting the power that they had over these critical distribution networks. I think another tenet of the anti-monopoly movement that we're now seeing is that antitrust really needs to be focusing on the structure and process of competition rather than any single metric, welfare-based metric. So one of the big shifts in the last few decades was that we decided that the single goal of antitrust should be to promote consumer welfare. And in practice, that has meant that enforcers look at short-term price effects, short-term output effects. There's a debate about whether consumer welfare could be expanded to cover other metrics, but in practice, given that price effects are often the ones that are most measurable, that's what enforcers tend to look at. I think this is a mistake, and I think that's partly because we've adopted consumer welfare as a proxy for what competition is, but it fails to actually capture what competitive markets look like. And so I think there are a host of ways in that you can see anti-competitive conduct that don't actually register in terms of consumer welfare. I think pushing back against consumer welfare often gets mistaken for the view that antitrust really needs to move in a direction where we're balancing all sorts of other considerations like the political power of companies or their income of workers. That's not what this position that I think a lot of people are pushing towards necessarily encompasses. I think you can move towards a system that really focuses on what the competitive structure of a market looks like in ways that are not being registered merely by, say, price effects. I think lastly, it's worth noting that I think our current antitrust laws have a deeply kind of libertarian bent to them. I think there is a kind of Chicago school assumption that market structures emerge through natural forces, that there are all these kind of metaphysical phenomena that determine what markets look like. That's deeply antithetical to how we actually used to recognize that market structures are a direct product of our laws, of how we legally choose to structure markets. And I think recovering a approach to anti-monopoly that again recognizes that how markets are structured directly traces to how we choose to structure them through laws. I think that's really important. I think it's definitely true that certain technological developments unleash new forms of consolidation and concentration, but in the past we've responded to that through restructuring these markets and reviving and kind of recovering our laws to ensure that concentrations of power are again kind of targeted to ensure these markets are competitive. So I guess I'll leave it there and look forward to the discussion.
Sure. Thank you, Lena. So actually, you reminded me one of the aphorisms you hear about the marketplace is voting with your feet, but it really is with choosing your product. The competition is really about your vote in the economy rather than your vote for government or something like that. So our next speaker is Sally Hubbard. She's currently the senior editor of the Capital Forum. She did the path that I probably should have done, which is she was an attorney and turned into a journalist. But she has covered some fascinating topics since she has become a journalist. one of the things that I really wanted to kind of start out and ask you, and I think Michael touched on this a little bit, but for about 2 years, there's been an uptick in news coverage of antitrust as an issue, and everything from the New York Times. I've got an article from The Nation, also your article in Forbes, and so this has really become an issue, and I feel like we're currently in a very populist era, and if you look at the history of antitrust, it started in a populist era as well. Can you just talk more about, kind of with the news media and everything that's how we're hearing more about this now, and what do you think it means?
Well, the news media itself is suffering major consequences from the consolidation. So that's actually what I wanted to talk a bit about that. And of course, some of the points that was made earlier about the political situation that we're in now. I mean, antitrust came about as a result of populism. Populism comes about as opposed to concentrated power, and I need to do something about it, right? But what I've been focusing a lot on is I wrote an article back in January 2017 saying that fake news was in fact an antitrust problem in part, not entirely, but in part. And what the current news media is struggling with is that Facebook and Google are eating up more and more of the digital advertising revenue. Last year, I think they accounted for, the estimates vary, but it's between 70% on the low end and 99% on the high end of how much of the digital advertising revenue Facebook and Google together accounted for in the US last year. Now, this is the revenue that news companies use to pay for their journalism, right? So in the era of fake news, we actually need our news publishers to be able to fund their journalism, right? And I think, the other issue that's been in the news a lot has been about the tech platforms, because of Facebook and Google controlling so much of the digital advertising revenue. This is just becoming more and more to the fore. But George made the point about he views antitrust as being about economics, and Lena pushed back on that a little bit. And I'll say that I'm more in the camp of Lena, where I think that antitrust is about competition. And when you focus on, and economics was kind of a way to have a standard to prove a harm to competition. And the problem we've had with the tech platforms like Facebook and Google is that to the user, they're free, right? We're paying with data, we're paying with attention, but we're not paying with money. So this is why they've kind of been able to run amok without any antitrust enforcement, because there's no way for those antitrust enforcers to show that prices have gone up, because they got into this very narrow view of looking at competition, right? So if you're obsessed with prices, then it's like, how do we use antitrust law to look at tech platforms when they're free? If you are focused on competition, well, it's obvious. To me, it's very obvious. What you have are tech platforms that are controlling the arena in which the game is played, and they're also players in the game. So how can you possibly have a level playing field for competition? So to me, antitrust is about having a level playing field for competition, having pathways for opportunity for new upstarts to come in. But what we have now with the article I read about fake news, I was emphasizing that Google and Facebook are actually competing against every website on the internet. They're competing against every news publisher, because the way that they make their money is by keeping users on their platforms as long as possible. The longer they keep you on the Facebook platform, the more data they collect about you, and the more advertisement they can show you. The moment you click off and go to NewYorkTimes.com, they're losing, that's against their business interests. They want to, you only have so many hours in a day, and the way that they're going to grow is by taking more and more of your hours, of your attention, right? I mean, literally, Zuckerberg, I think it was 2017 earnings call, he was saying, we are up for 40 minutes to 50 minutes now. He's actually giving this as a stat to investors, like this is how much more time we're getting of users' time. So they're literally in direct competition with all the news companies. But the news companies are completely dependent on Facebook and Google to be discovered. Unless you just go to NewYorkTimes.com, yes, people still do that to some extent. But, we've got, Facebook has 2 billion monthly users, Google controls 80% of searches, and this is, they both have a huge role in the way that people consume news, but they also have a stake in keeping people on their platform. And the way that they do that is by creating engaging content. And engaging content, sadly, the algorithms have learned, is content that inspires fear and anger. So a lot of these problems, I won't go any more into the detail, but a lot of the problems that we're seeing with political polarization, election interference, and fake news are being driven by the business models of Facebook and Google.
Thank you, Sally. So I'm actually going to turn this into a discussion now. I'm just going to actually kind of throw this out because it's something that Sally mentioned, the concept of a level playing field. And I think it touches on a little bit of what Michael was talking about earlier, that people feel that the game is rigged, that there's something going on. So when we're talking about a level playing field, what exactly is that? Can anybody talk about what their vision of a level playing field is? Anybody? Michael, do you wanna? Yeah, sure.
So, I mean, I guess for me, yeah, I've said this to some people that there's this sort of debate: is the consumer welfare the right standard? And I guess, when I go back and I look at what the antitrust doctrine's about, I think the consumer welfare standard doesn't direct you how to decide cases. It's a metric of what sort of harm you're supposed to be concerned about. But what we really mean, what the antitrust laws are supposed to, I think, protect, and it is something that you begin to see a lot more frequently recently in Justice Breyer's opinions, is it's supposed. What we're concerned about is harms to the process of competition, right? So, if two companies are competing and one is just more efficient and makes a better product for a cheaper price, and the other company goes out of business, that's the market, and that's the free market's nasty. If instead the two of them decide, hey, why don't we just merge and everybody will be more happy, that's not dominance is occurring not through the process of competition, it's occurring through an economic acquisition. That's what we're concerned about, right? So I think especially as we turn to things like tech platforms, or where we're concerned about the impact, say, on innovation, right? What we need to be looking at is what we're concerned about, the conduct at issue, whether it is a platform buying a very small company that may have potentially disruptive technology, or where in that situation the focus needs to be on: are they are we harming the process of competition? And I think that's consistent with a consumer welfare standard, but I think that lens gives you a much broader understanding about the roles of the antitrust law. And I'm sorry, just one quick thing to sort of maybe make this a little clearer is, as George well knows, I've spent a long time on one particular issue which involved branded companies paying their potential generic competitors not to enter the market. And I believe this from day one, back in 1999, and I believe this today, that this was an easy antitrust case. You don't get to pay your potential competitor to stay out of the market and then turn around and argue, well, but Judge, they may not have been able to enter because we had this patent, we could have blocked them, right? So we don't know that consumers were harmed, right? That's a misapplication of the consumer welfare standard, right? But understood, and it's much easier to understand, wait a minute, the process of competition is you can compete with your generic competitor, you can bring your legal claim and keep them out, but the one thing you can't do is say, I'm going to take some of my monopoly profits, I'm going to give them to you, and we'll just agree not to compete, right? And that's why I think understanding the antitrust laws as whether protecting the process of competition is vital for there to be vigorous enforcement. Sorry, that was way too long.
I think another thing that's important to look at is how open a market is, right? So if you're an entrepreneur and you have an idea that you want to bring to market and you think it's a good idea, you're able to secure funding for it, and you bring it to market, are you able to compete on the merits of that good or service? And I think we're increasingly facing markets where entrepreneurs are not able to compete on the merits of that good or service. I think this gets to some of what Sally was mentioning with regards to the tech platform. This is something that you see across the board, that you have, Google, Amazon that are now providing these infrastructure-like services for all of these other businesses, but Google, Amazon are also integrated so that they're in direct competition with the businesses that are using their platforms. What they do with that dual role is that they kind of scoop the insights of the entrepreneurs using their platform. So this is something you see routinely with Amazon, where you have, those independent businesses bringing products to market, and then Amazon will see that those products are doing well, and then will either go directly to the manufacturer, undercutting these merchants on price, or now that Amazon's built out its private label, will just produce a direct replica of that good. So here you have a situation where you have these independent entrepreneurs or businesses undertaking the initial risk of bringing a product to market, but it's the platform that's been able to kind of reap the reward of that risk. I think that's a system that's not good for entrepreneurship and that's not good for innovation, and really is antithetical to what antitrust was supposed to promote. So I think ease of entry and whether entrepreneurs that are able to bring a product to market are able to compete on the merits of that product or service, that's important to look at.
Yeah, so I'm hearing a couple of, actually multiple strains in this conversation, and I think it highlights why I made the remarks that I made at the beginning of the conversation. Lena was saying in her remarks, and I hope I don't mischaracterize them, but she'll tell me if I do, that we ought to be concerned about the monopoly problem, not only in terms of its economic roots, but because of its implications for political power. To me, that creates a dilemma. And the dilemma I'm going to characterize in this context as the goose and gander problem. And it's a problem that comes up anytime you try to introduce non-economic criteria into the antitrust debate. So the goose and the gander problem is you've got these centers of power, Google, Facebook, whatever folks you want to put out there as centers of power. And the question the way I hear Lena's proposition, the question is whether they ought to be out there as separate centers of power, or whether they ought to be pulled under the thumb of the federal government using antitrust laws as a vehicle. I would say to this crowd, I know that not everybody would agree with what I'm about to say, but to this crowd, I would guess you probably don't want Donald Trump dictating to Facebook and Google. You probably would want them to be outside the sphere of Donald Trump's influence as independent actors in the political space. So the question becomes, how do we regulate who gets to regulate? How do we decide how much power to give that person? And I mean, Elizabeth Warren, I think, is facing that now with the Consumer Finance Protection Board, where their efforts to rein in what they're not doing in an environment where they were created with no accountability to the Hill or pretty much anybody else. To me, that cautions for pulling back and not treating antitrust as the aspirin of the legal world that can fix all cures. It has a specific purpose and is intended for a specific purpose, and it ought to be limited to that purpose. One other quick comment. I heard the comments about the USDA and the FCC and the DOC and all the other anti-monopoly agencies. And again, I lived through the deregulation of the airline industry. I've seen what's happened to prices in airlines since. And no matter how much we hate flying the airlines today, the idea of flying from here to San Francisco for $200 back in those days was totally unheard of. There are costs to regulation. And those costs are significant. And if you go back to the 70s, to the whole deregulation movement, which, I mean, some people claim credit in the Reagan administration. It happened in Carter. I was there. Carter was advocating at the CIB for deregulation as the starting point, moving to the ICC, et cetera. And the reason was plain and simple. We were facing a global economic threat. We were being outcompeted by the Japanese. And the notion was, we've got to become more efficient. So the question is, at what cost will we do this regulation? Alternatively, can we have an antitrust regime, which I agree with Michael 100%, which is designed to preserve the competitive process, and by doing so yields a result without centralizing power and all of the costs that go along with co-option of regulatory agencies, incompetency of regulatory agencies, mistakes by regulatory agencies.
I want to say pulling back from what? Cary said we need to pull back. What is there to pull back from?
Pull back from the notions that antitrust ought to go beyond its scope to dealing with issues of income inequality.
I mean,
So I just want to clarify that's explicitly meant to say that identifying as a descriptive matter that concentration of industries has political ramifications is not the same as saying that therefore the political power of companies should be factored into antitrust analysis.
Okay, that's
These
good
are,
to hear.
Yeah,
That's
these are separate
very good to
things.
hear.
Yes.
I want to.
George, I think there's really interesting points, but so my question is, like on airlines in particular, right? One can say that maybe deregulation in the 70s was a good thing,
Yeah.
but it seems to me that it's arguably exhibit one for the ineffectiveness of antitrust law in the 21st century, that for some reason, and you can blame the enforcers, but I think you also have to blame just the legal standard has made it prevented the consolidation of the industry to the point that it is one of the, they're earning billions of dollars of profit and, increasing fees right and left and reducing service. I mean, it may be one of the worst performing industries in America, and maybe the only saving grace is that at least, it's not, well, I don't know that there is one. So,
Actually, Alfred Kahn, who was one of the chief kind of architects of the deregulation movement, shortly before his death, was kind of interviewed about how he thought the airline deregulation had gone, and he said one of his main regrets was that there had been no antitrust enforcement. Like, he saw the deregulation as a failure in part because it had not been accompanied by strong antitrust. So I think, to echo Michael, that's a kind of an exhibit A for where things have gone awry.
Okay, so first of all, I think everybody knows that I'm here as a stand-in for David Gelfand. I know if he were here, he would defend vigorously the antitrust enforcement of the Obama administration in the airline industry. I'm not going to do that. He and I have had some discussions on this topic. I agree that there are mistakes that are made. Part of it might be the legal standard, but I think if there's an issue on the legal standard, it has to do with burdens of proof, not the underlying analysis. I think that's a legitimate point, and as we said before, there are legitimate debates about what the burden of proof should be and how aggressive one should be in that regard. But I totally agree with Professor Kahn that the the Department of Transportation administration of airline merger review during the 80s and 90s was terrible. They allowed consolidation in hubs in a way that they should not have allowed, but I think traditional antitrust tools would have told them that. I think it was non-antitrust imperatives that drove those conclusions, notwithstanding the fact that the Secretary of Commerce was a former Federal Trade Commissioner and should have known better.
I don't want to leave you out.
Oh, I just want to say, on the pulling back point, we had a recent conference where Tim Wu was a speaker, and he gave a great quote, which was that antitrust has been on a starvation diet for the last 20 to 30 years. So I think we've seen what happens when they pull back. We have unprecedented consolidation, political discontent. It's time to try something different.
Okay, so another thread that I wanted to actually pick up on, and this was actually just came from George, we were talking about burdens of proof. And so interestingly, one of the ideas in the Democrats' better deal is shifting the burden of proof for merger review to put the burden of proof on the merging parties to prove that the merger would be a good or be a benefit more than it would harm competition. So that's an actual change in the law that can occur that would help things. We have a federal bench now that has been basically following a doctrine laid down by Robert Bork, since in the late 1970s, and getting them to change this body of law is going to be difficult. Are there other things other than changing the burden of proof that we could do in terms of changes to the law that would give both the government and private citizens, if they want to, tools with which to make the changes that they want to see? Let's see.
I went first last time, so.
Lena?
Sure. I mean, I think it varies by kind of conduct by conduct. So I think there are certainly areas where, the government has room to be a bit more bold or creative with certain kinds of theories of harm. And I think, potential competition being one example where I think there's opportunity for more robust enforcement, even given the current law. I think there are other areas where, the Supreme Court has issued decisions like around predatory pricing, where it's now extremely difficult to bring a case under the current law. In predatory pricing doctrine, the court has basically said that there's kind of a presumption against predatory pricing. So the court has said it's irrational and rarely ever occurs, and introduced a burden of proof that requires showing recoupment, so that you have to show not just that a company was pricing below cost, but that it has a reasonable chance of recouping its initial losses. For all sorts of reasons, this is extremely difficult to show. But I think more generally, the entire premise of this doctrine, of this burden of proof, that predatory pricing is unlikely and rarely ever to occur is unfounded, and there's been a lot of now empirical work showing that actually predatory pricing is not only not irrational, but in fact is very rational. This is especially true in platform markets where there's an incentive to kind of capture the market, right? There are winner-take-all dynamics here because of network effects, and so oftentimes you see companies engaging in, predatory pricing or kind of undertaking losses in order to capture the market. So I think that's an example where you would, actually need statutory intervention to be able to bring cases. But I think, that being an example of, one area where you would need it. But I think, the merger guidelines are flexible. I think there are other areas of enforcement where the agencies could do more, even under current law.
Sure. So another, I was going to, did you want to?
Can I add
Sorry.
one thing? In addition to kind of some of that pesky precedent that's out there that makes things harder, there's a lot in the monopolization context too, and under Section 2 kind of that make the standards really hard for enforcers to win, and therefore they don't bring the cases. Even if we didn't have any reform, even if we didn't change the consumer welfare standard, even if we didn't change any of the case law, we could just bring more cases. I think the standard that the agencies have right now is that they won't bring it unless they think it's a slam dunk or they're definitely going to win. And to me, that's under enforcement. Like if you have anti-competitive conduct, and it's maybe a challenging case under some of this precedent, this misguided precedent, bring the case. I mean, if we had murder enforcers, the DA was like, I'm not going to try this murder case unless I'm 100% sure I'm going to win, we would think that was under enforcement, right? So even apart from any kind of reform, any kind of standards changes, just bringing more cases, I think would go a long way.
So I want to jump in. I don't really entirely agree with that because the precedent does matter. And I think there is a tendency to undersell how limiting the precedent is. And, if you look at what the FTC's enforcement, antitrust, and just agenda was since the late 1990s, they had to spend 2 decades convincing courts that hospital mergers in small that the range of competition is very small, that people won't travel 60, 70 miles to get health care, to have babies born, to have surgery, and it took them 20 and they continue to have this problem. So to say that the FTC was only bringing cases it could win is actually not true. They spent a whole bunch of resources bringing a lot of hospital mergers that they didn't think they could win. If you go way back to the late 90s, George litigated the first FTC case challenging Staples Office Depot. And I can remember when that case came out, like everyone said, that was the most ridiculous case ever because the FTC was challenging the pencil monopoly. And we actually that case was one of the high points of merger enforcement, and was not a case that people thought they could win. When I just talked to you about these patent settlement deals, another decade-long fight. I have the scars to show. Each time we kept losing, and people were telling us not to bring cases. So, and I think all three of those should have been easy cases. Right? So until somehow the courts stop making the government having to prove basic competition cases, it's not going to be able to bring the more interesting or the more aggressive cases. And that's just the fact of where the judicial precedent is. And that, I think, is even more true when you look at this Supreme Court. Any sort of new case, you need to think about the fact that it's going to be Justice Gorsuch sitting in Justice Garland's seat, driving the antitrust analysis. And that's why I think, going to your question, and I'll finish up, is why Congress needs to really think about resetting the rules of antitrust law, because I think that the Supreme Court is not about to change any of the things that might improve antitrust enforcement.
Michael, just to clarify, I do think we should change the precedent, but I also think we should bring more cases.
So I want to go back to Lena's comment about the law, because I think this is fundamental, and maybe it goes to the heart of this discussion. How many here took Uber to get here tonight? So how many of you would be happy paying 3 times as much for that car ride? Okay. Next time, take the SUV. So look, if you can talk about predatory pricing. It's hard to distinguish predatory pricing, especially where there are high fixed costs and very low variable costs, from price competition. Uber is a little cheaper than a taxi. It's not that cheaper. They lose billions of dollars a year. Nobody quite knows why. That could be predatory pricing, and without a requirement that their prices are so low because they will achieve a monopoly and then be able to raise prices later. You don't want a law that says, Uber, stop charging such low prices. Any kind of statutory change to the recoupment element would result in just that, and that is anti-competitive, and I think it's something to be avoided. Now again, one can talk about quibbling on the edges about what kind of proof is necessary for recoupment, but these kinds of changes that basically say the plaintiff wins are really dangerous and really costly. And they're not only costly domestically for everybody who takes Uber, or now you have to pay to get on Google to look up that case precedent that you don't remember how to look up any other way. It's not only that, it's also in the international economy. And, I can tell you that I've been to China a dozen times, and I've talked to Chinese regulators who are fully prepared to bring in all kinds of considerations into how they decide their antitrust cases. And anytime the U.S. deviates even an inch from recognized economic standards, they will throw that in your face and use it to come up with decisions that are nothing but outright theft of intellectual property, of unfair competition, etc. Again, goose for the gander, number 1 and 2. Whatever we do here, they're going to do there. And when they do it, they're going to enforce it in a way that disadvantages us and advantages China, Inc. So I'd be very, very careful. One final comment going back to Michael's point. Michael is absolutely right. That was an easy antitrust case. And that's what I told your boss on the golf course when he was agonizing about whether he should bring it or not. The problem with that case, from my point of view, was that the courts decided, rather than applying antitrust economic principles, were bringing in disparate values that they couldn't equilibrate, namely IP protection, in a way that obfuscated the antitrust issue. If they had come in and said, economic analysis, monopolists can't pay a competitor not to compete, we're not going to consider anything outside that frame, for example, IP, the sanctity of IP law in that context, I think it would have been a much easier case.
So just quickly, I think there are ways to reform predatory pricing law that make it plausible to bring a case when there is predatory pricing that are not simply the plaintiff wins. And I think this goes to a deeper point about the current state of the law, which is that there's actually like an assumption of under-enforcement embedded in the current law, and this really traces back to the assumption that Bork basically said it's unlikely that a company will ever really attain monopoly power, but if it does, it's unlikely that that monopoly power will persist, because anytime a company is able to acquire monopoly power, it'll start raising prices and you'll see this flood of new entrants. So there was basically an assumption that any monopoly power that ever does arise will be fleeting simply because it will be competed away. I think in practice, there are actually entry barriers in many more contexts than is assumed, and monopoly power often does persist. So I think kind of reforming the law such that it actually takes more realistic account of entry barriers is really important if we want to get to a point where we see real enforcement.
So great. That's a extremely good point. And one of the things that I was thinking about when we're talking about predatory pricing, I mean, Amazon is kind of a favorite villain for various things at this point. In terms of that, you have a company that has as much revenue and as much the willingness to forsake profits for growth year after year. The fact of the matter is that maybe we have found a company that can successfully predatory price or successfully set a price that's predatory and eventually close down the little shops on the streets because everybody's just going to get their stuff delivered from Amazon. So there's a whole ton of stuff in here. I know so I have kind of a list of different things we kind of want to talk about, but there's three major things that I heard kind of in the power about economic power and what it can do. One, it can create political power, and another thing about how monopolies persist is sometimes maybe a company that gets a lot of economic power, it can then go and kind of seek regulation that will entrench itself as the main company, and you saw that actually with AT&T. Many years ago, income inequality and gender inequality. And I know that the panelists had some kind of views on whether or not, like those particular topics, and I was wondering if they could talk about it. And actually, I'll go to you, Sally, because the gender inequality one is the one that interested. It was a fascinating article. So
thank you. Yeah, this was part of my own kind of conflict of being, it was last year, I write about tech platforms and antitrust, and I also have a podcast called Women Killing It, where I interview successful businesswomen. And just for someone who's passionate about antitrust and tech platforms and women's issues, it was a really exhausting year, right? So I was like, everything is blowing up. I've got to pick one of these things. I can't keep doing both. And that's when I kind of figured out, how did I not see it before? It's really the same passion. It's about equal opportunity, right? So the competitive equal, as Lena was saying earlier about how she views a level playing field, it's the open market where if you come out and you have the best product and the best service, you have a chance at, succeeding. You're not just being blocked out by a monopolist or the markets are not closed out, right? And that's the same thing with feminism, right? Like if I am the best, I would like to have a chance, even though I'm a woman, right? So, and not be, the glass ceiling is just another cartel, as I wrote in my article. And people like Lena have done great scholarship on the connection between, these consolidated markets and inequality. And but no, everyone had been talking about income inequality, and then that was when I was like, well, if it's affecting income inequality, it's going to hit women extra hard because we're already at the bottom of that game.
Sure. And
so I want to sort of maybe step back a little, go up to 30,000 feet, although I hate that cliche. But then I guess I can bash airlines again. No, I think it's really great that ACS is having this topic because there can be there's sort of this, you've heard a lot of sort of disagreement amongst the panelists about what needs to change on antitrust law and what doesn't. But the most fundamental issue here is, as ACS, you guys have this is an organization that has been in the forefront of sort of pushing back on conservative ideology, whether it be in criminal law, constitutional law, civil rights law. And I think regardless of these panelists and our disagreements, one area where the left has sort of ceded ground is not realizing that economic regulation, antitrust law, that is there is as much of an ideological battle going on, and it's very interesting, right? When the conservatives are nominating judges, either they come straight out of the most hardcore Robert Bork said everything right, antitrust law basically has very limited scope, or there are people who are going to just take that position without knowing, right? Whereas on the Democratic side, on the left side, there has been really no concern about where judges stand on this type of issue. And the result means that on the one side, you have one side of the judiciary, I think, takes a very technocratic approach, but the other side is taking a very subtle ideological approach. And I think we on the left have underestimated how much damage that inconsistency has done, right? And that the direct, particularly where conservatives want to take antitrust law, where it is today and where they want to push it, in ways that reinforces economic power and political power in ways that we should all care about, even if you're not an antitrust lawyer.
Yeah, I'm really glad Michael brings up this asymmetry, because I think it's also something that really filters down into law schools. And I think oftentimes law students, if you have like public interest oriented law students, there are a whole set of areas of the law that they view as being kind of vehicles of public interest. So like environmental law or immigration law or constitutional law or administrative law, and antitrust law just doesn't really even feature as one of them. And I think ACS in particular, given kind of the student chapters and the kind of robust network that it has in law schools, has a really great opportunity to ensure that antitrust law, like these other areas of law, becomes recognized as a site of public interest work and starts attracting more law student interest, so that we really get a lot more fresh thinking in the space.
And I just wanted to quickly, so one of the worst, what I think one of the worst antitrust decisions in the history of antitrust law it came out in 2003. It was a case called Trinco, and it was written by Justice Scalia, and he begins with this just glowing honorarium to monopoly. Monopoly is awesome. It's the best thing ever. We really have to be worried about the government interfering with people getting their rightful monopolies. That case was 6-3. The three who concurred, they wanted to avoid the merits. They said there was a procedural reason the court shouldn't relate to standing. Interesting enough, Justice Ginsburg, Justice Breyer, at the time probably the two most liberal members of that court, sided with the majority. Right, and so this is sort of what I'm sort of putting a fine point on. When you sort of attack Trinco, the conservatives all point and say, "Well, how can Trinco be bad? Because Justice Ginsburg is on our side." And there needs to be a recognition that that the same ideological war that is being waged in civil rights constitutional law is going on even in antitrust law.
So we are actually getting close to the end of the panel. I wanted to open it up for questions from the audience. So please raise your hand and wait for the microphone to be brought to you. Thank you.
Hi, thanks very much. I have a quick question about an obvious target, I guess you would say, would be Apple computers. I think they've really risen extraordinarily well in the last decade, almost coming out of nowhere, seeming like a minority part of the business, and now a majority part on the college campuses and on our hands and in our briefcases and so on. So how did that happen, and what commentary does that have to do with what you're talking about now?
So I will actually kind of start. I'll start answering it, and then I'll let the panelists kind of chip in. So I view Apple as a company that actually was extremely successful in creating products, but they were also extremely successful in creating a market within their product that they can control completely. And I'm kind of wondering whether if anybody could kind of riff off of that in terms of are there any anti-competitive aspects or things that you would wonder about for the Apple ecosystem in terms of the App Store and those sorts of things?
Yeah, in some ways, Apple has avoided antitrust enforcement by being even more of a monopolist because they just made it such a closed system One of the cases that Google has going on in Europe right now is the Android investigation. And Google had entered into agreements with the companies, or according to the investigation, I haven't seen the agreements, but agreements with the equipment manufacturers, the people like Samsung's, the companies that make the phones, saying, if you want the Android operating system, and if you want the Google Play app, you have to take these other 30 apps. And the Google Play app you need to have because that's how you download your apps on an Android phone, right? So they're being investigated, and that could be a monopoly, an abuse of dominance case. It's that they rammed all these other apps in, which is a perfect example of if I come up with a great app, it's not going to get pre-installed in an Android phone because Google has put these agreements that say you can't do that. Now, Apple hasn't had anything like that because it makes its own phones, and it actually does. It has a closed operating system. So in some ways, by being more closed, it's actually shielded itself from a lot of the antitrust enforcement. So it's quite a robust monopolist. And when you try to plug in a cord that's not Apple, you get the notification, this is not our Apple cord, right? I mean, they make sure that everything is Apple. So they've been pretty effective in that way.
And so I'll say one other thing is Apple actually, I believe, was one of the companies that were making agreements. A number of the Silicon Valley companies were making agreements with employees, and no poaching agreements and things like that. So they haven't been as good in certain respects as anybody else. So any other questions?
I just wonder also if you could comment on the denial of the two big mergers in healthcare last year. How was that tied into Obamacare and some of the issues you've been talking about? If there is
I think those represented aggressive challenges by the government. I think people didn't, I think when they were filed, people were not sure whether the government should win. I think they were both correctly decided. I think, in terms of if I want to find a silver lining in antitrust law, I think the district court sort of understanding that when we look at a market, right, whether it be the producer raising prices to the consumer, that's a problem, but it's also if the buyer eliminates competition and is going to be able to extract lower prices from doctors, not because of an efficiency, but because there's no competition, right? And so those were all good. And, and I think the rejection of the notion that the ACA made us do it was an important the right development. So, I thought, they were sort of a bright spot in an otherwise really dark year for all sorts of reasons.
I guess I agree with the last part of that. I think it was a correctly decided case, but I do worry, again, in terms of bringing in all these other aspects of our political discourse into antitrust. It is just a fact that part of Obamacare was designed to create monopsony. Countervailing market power to drive down costs was a central feature of what the architects of Obamacare were trying to do. One can argue about whether they did it very effectively, but then when market participants react to that by creating the market power to drive down the costs, which we call an antitrust monopsony, the DOJ then comes in and sues them. So now the question is, do you want some grand scheme of a total regulation that solves that problem, or do you want antitrust to focus on the antitrust question? I think it was correct to focus on the antitrust question. I think they got the answer right. But this whole idea of one part of the government telling you to do one thing and another part telling you that it's illegal to do it is a problem which flows from comprehensive regulation.
So I'll do two more questions as we actually have a little extra time. We're going over an hour, but go ahead there. Can we get over there? Sorry.
Hi. So I heard two things. One, that the lack of or the ineffectiveness of the current precedent around antitrust regulation is a underlying reason for political discontent, and also that that there is a current ideological strife going on that those on the left aren't necessarily prepared for in terms of antitrust enforcement and where those on the right want to take it. So my question would be, for those on the left, how politically do we take a topic that is sometimes as esoteric and removed as antitrust regulation and weave it into a political narrative that's compelling for people, that they understand the benefits of a more robust antitrust enforcement regime that it could produce for their daily lives?
So I'll start that. I think you need to go back to Teddy Roosevelt a little bit and take a kind of an example, from those days about why the arguments were made regarding, the size of companies and why we wanted to deal with these trusts and deal with the large trusts in the first place. I think that there is an intuitive portion of people that understand that large companies having too much control or too much power is a problem, and you see that with campaign finance reform. I mean, there are people talking about how corporate speech is drowning out individual speech when it comes to voting rights. There's knowledge out there that it's an issue, but what needs to be done is connecting it to the state of the law itself too, and perhaps even changing the law. So.
Yeah, there are a couple of candidates running in 2018 that are trying to build a campaign around anti-monopoly issues. So I think it'll be interesting to see how those go. I mean, it's easy to forget, but antitrust was like the key issue in the 1912 presidential election. People were really debating this in a very concrete day-to-day sense. So I think it'll be interesting to see if we can get back there.
I think some of the easily understood things are, your cable bills, right? There's pocketbook issues where there's not choice and competition that leads to higher prices for consumers. That's like in terms of just, I know some of the politicians that are running on these issues are talking about those things with their constituents. And
also I think on wages, I mean, there's been in the last few months this terrific set of studies coming out kind of quantifying the degree that monopsony power in labor markets is affecting wages. Marshall Steinbaum, who was here but just left, has been one of the key people kind of in the economics world doing that work. And I think, for a candidate to be able to come out and give a precise dollar figure that is that like monopoly accounts for, and when it comes to your wages, is a really powerful thing. So I think that's a great opportunity for people.
So, and I just want to echo, I think that's a great point. I mean, I think, speaking solely for myself, I've spent 20 years enforcing the antitrust laws and probably never really thought that monopsony, at least in sort of wages, was a problem. And I would have to say, looking at the studies that have come out in the last year and the last few weeks, that was a mistake. And that, but I think that if to the degree that research holds up, and already we need to start thinking about that should change our enforcement agenda. To the degree concentration and mergers are leading to lower wages, that's a real pocketbook issue and one that should be a top priority where it's a problem.
Okay. One more question.
So that actually ties in exactly to what I've been wondering this entire time, which in my non-technical perusal of economic data, there's actually over the last few years been a lot more studies and a lot more data coming out talking about monopsist power in driving down wages and capturing what we would generally consider monopoly rents on the labor side as compared to the consumer side. And I was curious if you'd seen more interest developing both among policymakers, but also in the judiciary and among practitioners in kind of the monopsolist angle of antitrust evaluation as compared to the purely consumer-facing, consumer welfare side over the last few years.
So I would say absolutely. I mean, if you look, right, you have the Justice Department bringing cases going after companies for no poaching agreements, right, where Intuit and eBay, who clearly don't compete on the product market side, we're agreeing not to poach each other, right? So, and bringing that, and then that being followed by a Republican in charge of the DOJ now saying, we're going to think about bringing that criminally. So we're going to start thinking about bringing those cases and putting people to jail. You saw Joe Simons, when, in his questionnaire talking about the antitrust laws need to protect workers, and I very much think that he is reacting to this research. So I may be wrong, but I see things shifting in terms of priorities. I don't know what others think. But.
I think there's also interest on the Hill. So Senator Booker, Senator Warren, Keith Ellison, they're all kind of thinking about potential statutory changes that could address monopsony power more overtly. The Klobuchar bill that you mentioned also included kind of including a line about monopsony more overtly in the Clayton Act. So.
All right, I want to have everybody join in congratulating the panel, and also Cleary, thank you for hosting, and George, thank you for being our foil.